Welcome to this lecture webinar from the Royal Society for Asian Affairs. My name is Bill Hayton and I'm the editor of the RSAA's journal, Asian Affairs. For those of you who don't know the RSAA, we were founded in 1901 and we exist to promote a better understanding of Asia in the UK and around the world generally. And as part of that mission, we're joined today by Professor Surya Subedi, who will talk about the learnings from his 2021 book, Human Rights in Eastern Civilizations. Professor Subedi was born and took his first degree in Nepal and became international legal advisor to King Birendra. He moved to the UK and became an academic in 1993, and along the way has helped to establish the Asian Society of International Law and gone on to teach at universities in the UK, the US and the Netherlands. He's published 12 books and more than 60 scholarly articles across many areas of international law. He's a King's Counsel in London and also Professor of International Law at the University of Leeds, and Leeds is where he joins us from today. Professor Subedi's book addresses the contributions of Eastern civilizations to the development of the international human rights agenda. There's been a lot of talk, I think, in recent years about whether human rights are a Western invention and whether they are some kind of Western imposition on the rest of the world. But I think Professor Subedi is going to maybe try and challenge some of that thinking and talk about how Eastern civilizations have contributed to the discourse. So Professor Subedi will talk for about half an hour, I think, and then we'll have some time for questions and discussion afterwards. Professor Subedi, over to you. Thank you.
Thank you. Good afternoon to you all. I would like to begin by thanking the Royal Society for Asian Affairs for inviting me to share my thoughts on human rights in Eastern civilizations. I also would like to thank Dr. Bill Hayton for his generous words of introduction, and to Charlie Portlock for organizing the talk. I am honored and delighted to join you online this afternoon. I welcome the invitation to speak on this topic, since I recently have published a book on human rights on Eastern civilizations, which looks at how cross-fertilization of values between the Eastern and Western civilizations has taken place and how they have informed the crystallization of human rights as universal values. There has been a great deal of debate in the recent past about decolonizing the curriculum in universities around the globe, and a call for the use of more inclusive and diverse sources for teaching. I hope my book makes a contribution to our understanding of human rights from a historical and wider context. When discussing human rights, I'm not only referring to human rights in the modern sense of the term, that is, the human rights developed mainly after the establishment of the United Nations and within the framework of Western political thought. Rather, I examine human rights in a wider sense and in a much earlier historical context. I focus on the norms underpinning Eastern philosophies to assess the extent to which the ancient Eastern civilizations already had human rights values embedded in them. When we speak of Eastern civilizations, we may include most of the civilizations of the Asian continent, since Asia is home to all major religions of the world, including Christianity, Islam, Judaism, Hinduism, Jainism, and Buddhism. All of them must be included within the term of Eastern civilizations. However, I will focus this afternoon only on Hinduism and Buddhism. The early civilization that grew in the Fertile Crescent reached its pinnacle initially in Babylon and later in Persia, and produced two early documents of immense historical significance: the Code of Hammurabi and the Charter of Cyrus. These two documents contain, in my opinion, the early elements of human rights. When the people from this region migrated both east to the Hindu Kush region, the Indus Valley, and ultimately the Gangetic Plains, and west to Greece and Rome, they carried with them the values of the Sumerian and Babylonian civilizations. Thus, these two historical documents seem to have influenced the values of Islam, Judaism, and Christianity when they flourished in the Middle East, from where Christianity spread further west and northwest, ultimately covering much of Europe. In an article on the origins of human rights written for the British Foreign and Commonwealth Office in 2015, Greg Dory states that, I quote, "Human rights are sometimes portrayed as a Western concept or invention, usually most vociferously by those committing the most serious violations. This is, in fact, a misreading of centuries of history which led up to the adoption of the Universal Declaration of Human Rights in 1948. Way back in 1539 BC, the armies of Cyrus the Great, the first king of ancient Persia, which is modern-day Iran, conquered the city of Babylon. In doing so, and as he prepared to govern his new territory, he decided that slaves would be free, people had the free to choose their own religion, and that different races living in the city would be treated equally, unquote. Now, turning to Hinduism and Buddhism, quite early on in antiquity, that is in the mid-1st millennium BC, the East experienced a frenzy of intellectual activity due to the birth of different philosophies of life. This was the time of middle way, nirvana, non-violence, and yoga, preached by Buddha and Krishna. The formulation of the Jain code of conduct by Nataputta, known as Mahavira, and the reorientation of the Vedic philosophies through the Bhagavad Gita by Krishna. All of these developments of the mid-1st millennium BC had a lasting impact on the lives of the people of the East, influencing thinkers beyond the East, such as those in ancient Greece, and shaping the religious and philosophical discourse to this day. Even the debate on forms of government was already underway in the East in antiquity. The thinkers and philosophers of the time, such as Buddha, and those who authored the Upanishads, about 200 of them, explored alternatives to monarchical authority and proposed alternative state systems with very different constitutions. The people in the Asian civilizations that developed along the Indus, Ganges, and Huanghe river basins were initially worshippers of the forces of nature, similar to other ancient civilizations. They all belong to one religion. Gradually, the civilizations along these rivers, which were evolved simultaneously and independently of each other, also became more sophisticated. Their philosophers started to question traditional patterns of thinking and developed new ideas to manage society better and to address the sufferings of the people. It was in the Indus and the Ganges river basins that the early religions, Hinduism and Buddhism, flourished. Buddhism was gradually adopted in much of Asia. It was taken to China from the passes in the Hindu Kush region and along the Nepalese Himalayas. And from there, it spread rapidly both within China and to Japan, Korea, and Vietnam, etc. Hinduism likewise is spread throughout much of South and Southeast Asia, thereby making Buddhism and Hinduism the main Asian religions. The civilization that flourished in the Hindu Kush region, the Indus Valley, and the Gangetic Plains came to be known as Hindu civilization, and its major offshoot is Buddhism, which in turn influenced indigenous beliefs and religions across Asia, such as Confucianism and Taoism or Daoism in China and Shintoism in Japan. Thus, the root of all major religions east of Persia, in my opinion, is Hinduism, which in turn has its roots in the Sumerian, Babylonian, and Zoroastrian belief systems. There are some similarities between the works of Plato and Hindu scriptures regarding matters such as the immortality of the soul and the organization of society along the lines of class according to a caste system. Plato speaks of three classes: the perfect guardians, the auxiliary guardians, and the third class. The status of the perfect guardians resembles that held by the Brahmins in Hinduism. The status held by the auxiliary guardians resembles the status of the Kshatriyas, the second highest caste in Hinduism. These two classes of guardians were supposed to rule in unison, which is similar to how the Brahmin Kshatriya rule under the Hindu system. The third class resembles the third Hindu caste of the Vaishyas, those people who work in agriculture, in the trades, in commerce, and in the service sector. However, the main difference between the two systems is that Plato's third class encompasses everybody apart from those in the intellectual classes, that is the perfect guardians and auxiliary guardians. While in Hinduism, a fourth class exists, which mainly comprises people who do menial jobs in the service sector. Slaves were not acknowledged as being part of the social hierarchy of Hinduism, and likewise are not mentioned as a class in the works of Plato either. They are thought of as a mere appendages to the other classes. The Brahmins who work to interpret Dharma are a class or a caste of their own, which is higher than that of the ruling classes known as Kshatriyas. The important thing to remember is that the Kshatriyas, who are the ruling elite, have no freedom to deny others the freedoms that they enjoy under the scriptures and in accordance with something called Sanatana Dharma. The ruling classes would be in violation of their own Dharma if they unduly intervene in the personal lives of individuals and would be held accountable for it. The Dharma or duty of kings or rulers is to preserve order by ensuring the performance of Dharma of one and all. The state is expected to follow a laissez-faire approach when governing, intervening in people's lives only when things begin to break down. How the state should conduct itself vis-a-vis citizens is regulated by the notion of Dharma, which is in this concept can be equated to the modern concept of the rule of law. There is no credible evidence to suggest that Socrates, Plato, or Aristotle was influenced by the scriptures of Eastern civilizations. However, it is possible that the cultures of ancient South Asia were studied by ancient Western civilizations. Western philosophers of classical Greek and Roman periods would have known how the ancient states in South Asia were governed, because there is evidence of interaction between peoples living along the fertile Indus Valley and the Gangetic Plains and the Greeks and the Romans. One plausible scenario which accounts for cultural similarities between the East and the West is that both Eastern and Western philosophers came up with similar ideas about the organization of society simultaneously, but seemingly independently of each other, and that their ideas were informed by each civilization's heritage. For example, Kautilya, the author of the Arthashastra, was a contemporary of Aristotle, and the detailed rules prescribed for different classes or castes represented in the Arthashastra are also present in the earlier scriptures such as the Manusmriti. These rules have many similarities with the laws of Plato. However, both the Arthashastra and the Manusmriti clearly mention and are influenced by much earlier Hindu scriptures, including the Rig Veda. The modern concept of human rights requires the state or those who exercise public authority to protect the rights of an individual. The Hindu concept of dharma does the same by requiring the king or the state and all members of society to follow their own dharma, under which they were expected to respect personal liberty of the individuals. Each person, therefore, has his or her own dharma or duty known as swadharma. Some duties are common to all, but when it comes to specific duties, which is concrete, which is correct for a woman according to dharma, might not be correct for a man. What is correct for an adult might not be so for a child, and so on. Thus, in Hinduism, people do not live under public law per se, but they have a dharma or duty or responsibility towards each other, including the protection of a personal liberty. Thus, in my opinion, the main difference between Western and Eastern traditions is the manner in which one acquires rights. In Western thinking, human rights are acquired through the declarations or proclamations of rights, using a legal or political instrument, starting from the Magna Carta, English Bill of Rights, the Declaration of Human Rights after the French Revolution, American Declaration of Independence, and coming all the way to the Universal Declaration of Human Rights. In Hinduism and Buddhism, however, rights are earned by a good conduct or adherence to dharma, or in Buddhism called dhamma. An analysis of the scriptures of the East demonstrates that Hinduism and Buddhism did not teach about human rights as we understand them today. However, both laid foundational principles for human rights and the conditions under which people can enjoy them. Although the perceived wisdom is that Western values ultimately found their expression in the Universal Declaration of Human Rights, many of these Western values themselves, in my opinion, have their roots in Eastern civilizations. It is, of course, debatable whether Western notions of human rights have influenced Eastern ideas or vice versa in later periods. Alexandrovich, the historian of the law of nations, argues that it was the tolerant and secular practices of the East that influenced the West. Please allow me to quote him. The European agencies in the East learned the lessons of coexistence of Hinduism, Islam, and Christianity in India, particularly on the West Coast, and transplanted their experience to the West, which had been so long incapable of extricating itself from the obsessions of religious wars, unquote. In my view, the values inherent in both Hinduism and Buddhism have had a profound direct and indirect impact on those thinkers and philosophers around the globe who had a universal outlook and who were willing to learn and be inspired by the values of societies beyond their own. This process, in turn, contributed to the adoption of the modern agenda of human rights and the adoption of the Universal Declaration of Human Rights. Those who claim that the notion of human rights is purely a product of Western Christian civilization are projecting reductionist 19th century values, that is, the values of the peak of the colonial domination, onto the past. They do not take into account the philosophical and spiritual developments that had taken place in the East prior to Western colonization. As I have tried to demonstrate this afternoon, the shared cultural heritage, integrating Eastern and Western thinking, adds further legitimacy to the universality of human rights and demonstrates how beneficial principles from Christian and non-Christian heritage can come together to further the advancement of human civilization. The same is true for the Universal Declaration of Human Rights adopted by the United Nations General Assembly, which embodies the values of both Christian and non-Christian civilizations, including Hinduism and Buddhism. Therefore, the claim that human rights are the values of the West alone ignores the origins of human rights. Likewise, the relativist or the so-called Asian values argument, advanced mainly by the autocratic and semi-autocratic leaders of Asia, has no basis in the cultural, moral, and philosophical foundations of Asian countries. People of all nations and backgrounds have the same aspirations to be free to pursue their happiness according to their own definitions of happiness. And the Universal Declaration of Human Rights represents that spirit and draws on the values of all major civilizations of the world: Eastern, Western, African, Latin American. In other words, the common aspirations of the people all over the world were codified in the Universal Declaration of Human Rights, and these common aspirations are as strong, if not stronger today, as they were in 1948. When the leaders of all the nations of the world gathered in New York in 2025 under the auspices of the United Nations, they all willingly and voluntarily stated that the Universal Declaration of Human Rights represents the aspiration of their people and regarded it as legally binding. Until that time, there was no clear endorsement of the legally binding nature of the Universal Declaration of Human Rights. That statement came along in 2005. Many United Nations human rights treaties, there are about 9 or 10 of them, we call them core international human rights treaties, embody the spirit of the Universal Declaration of Human Rights. That is, the treaties that seek to extend the scope and implement the provisions of the Universal Declaration of Human Rights were adopted under the auspices of the United Nations after the developing countries of Asia and Africa gained numerical majority in the United Nations General Assembly in the mid-1960s. It was the African countries that led, with the support of Asian and Latin American countries, the conclusion of the 1965 Convention on the Elimination of All Forms of Racial Discrimination, which is the first United Nations Human Rights Treaty with a monitoring and compliance mechanism. It was also the African, Asian, and Latin American countries that were behind the creation of the mechanism of United Nations Special Rapporteurs for Human Rights, within the United Nations jargon known as the Special Procedures Mechanism, a mechanism created to monitor the implementation of the provisions of the Universal Declaration of Human Rights and other United Nations human rights treaties. I had the privilege of serving as one of the only 12 United Nations Special Rapporteurs for Human Rights in the world. I served in Cambodia for 6 years. Therefore, my talk today is informed by both academic knowledge and practical experience of the work within the United Nations human rights system. there is a tendency to see the resurgence of the BRICS countries and also the Mint countries, in particular a communist China, and the emergence of a multipolar world is a threat rather than an opportunity to the United Nations human rights agenda. Concerns have been expressed in certain quarters that the economic rise of China may result in an eventual restructuring of the global political order and institutions in favor of China. In this vein, a great deal has been written about the possible impact on the rest of the world of the economic rise of China. It should be borne in mind that all states, including China, Russia, Iran, Saudi Arabia, and Cuba, have accepted the United Nations human rights agenda and have agreed to work with the UN human rights system. They have voluntarily subjected themselves to have their human rights records scrutinized by the United Nations Human Rights Council under a mechanism known as the Universal Periodic Review. In every 4 years, they have to submit their record of human rights and the progress made to implement the provisions of the Universal Declaration of Human Rights and other international human rights treaties, and they have been doing so. If a power is shifting to the east, it will not only shift to China, but also to established democracies such as India, Nepal, Indonesia, South Korea, and the Philippines, where the values of democracy and human rights run deep. Therefore, the shift in power to the east is unlikely to have a detrimental impact on the United Nations human rights agenda and the universality of human rights. The rise of BRICS countries in general and China in particular is likely to diminish the policing role of the West, but it won't undermine the essence of the ethos that underpins the United Nations human rights agenda. In other words, in my opinion, it will be down with the West, long live the values of the West, is going to be the future of human rights in the years and decades to come. Thank you for your attention.
Thank you very much indeed, Professor. That was fascinating. You reached back really deep into ancient history there to show us these connections and then brought it right up to date. I just wonder, we're going to ask participants if they want to offer any questions as well. But I mean, how, are there sort of, can you yourself, when you look at modern human rights documents, can you sort of go back to, the old, the Code of Hammurabi and say, kind of, this has a sort of direct parallel, or do you sort of see it as being so many layers of filtering along the way that it's difficult to see any direct connections?
If we look at the modern notion of human rights, perhaps those documents may not necessarily provide much evidence of it. But what I was trying to say, that how to organize a society. Human rights are basically about organizing society and respecting people's personal liberty. In the good old days, we used to say civil rights, now human rights. So respecting people's personal liberty and then organizing the society in a manner that is fair and just to everybody. And Code of Hammurabi aims to do that one. And more clearly, the Charter of Cyrus is, in my opinion, the first document which acknowledges the freedom of religion.
Mm-hmm.
And the declaration said, all of you within my empire are free to practice whatever faith you believe in. That's how the Jews, the Christians, and Muslims within the Persian Empire, led by Cyrus the Great, were allowed to practice their religion, and some of them were able to return even to Israel. Free, they were freed as slaves and were able to return. So when we say human rights, we mean a number of rights. And some of them, for instance, going back to, we say as international lawyers, a right to life is a number one human rights. What's the basis of the right to life? Non-violence. That's what the main message of Buddhism. If you practice non-violence, you kill nobody, you harm nobody. That's how you protect people's right to life. And if you practice secularism, if you don't intervene in the domestic affairs of individuals, then you allow them to exercise their personal liberty. And dharma, the concept of dharma in Hinduism and dhamma in Buddhism means the same thing. For instance, in many Hindu societies, many people who have visited South Asia, India, Nepal, there are so many, different persuasion, different sects operating very openly since time immemorial. The plurality has been in the lifeblood of this civilization for a long time. Even in Islam, if you go back to the Quran, the teachings of the Prophet Muhammad, even he said that you don't have to practice Islam if you are free to practice your own religion. But if you want to practice Islam, that's how you should do it. So only the teachings for Islamic people who wanted to follow the Prophet Muhammad. If you don't want to follow that one, you had no compulsion. That's how I think, in my opinion, the idea of personal liberty, the idea of non-violence, the idea of secularism, and the universalist approach to human life that began with the Charter of Cyrus carried on. In my opinion, of course, I'm not a historian nor a scientist, but many people say the South Asians, the origin of the South Asians, their journey began in Babylon, Mesopotamia. After the Charter of Cyrus was issued, they moved gradually to Iran, then further along to Afghanistan, through the Khyber Pass, ultimately to the Indus region of the Punjab, then to the Indo-Gangetic plains. So they carried on that message, that tradition. You can see in the religious scriptures of Hinduism. Having had primary education up to secondary level in Sanskrit, I can read for myself Hindu scriptures. Going through the Hindu scriptures, I could see the impact, some traces of influence of the Charter of Cyrus on Hindu scriptures, and calling upon people to practice a religion or faith which respects people's personal liberty. On that basis, I will say these were the early elements of human rights values. I would not necessarily call them human rights as such in the modern sense of the term, but what I was trying to say, human rights values were in existence in those civilizations in the distant past. And they have had an influence on Western civilizations, as I quoted both Gregory and then Alexander Wyss, which is a very highly regarded authority on South and Southeast Asia, how the colonies were operating, how the colonization began, what was the level of interaction between the people who went to India from Europe and the local community there. And he said that the practice that was in existence there, here in around Europe at that time, Spanish Inquisition, that Inquisition, intolerant, not tolerating the people practicing other faiths and religions. But contrary to that one, in South Asia, there was this practice of tolerance. So I think, in my opinion, tolerance is the contribution of the East. When the European societies were intolerant towards the people of other faiths, Asian communities were practicing tolerance, allowing people to practice their own religion. That's how it was possible for colonial rulers to have a foothold in Asia. If they were intolerant and prohibiting people of other faiths and religion, it would have been very difficult. Perhaps we would have seen a different course of history by now.
Thank you. I could choose out maybe there's, I think if I understood you correctly, a tension between the idea of Dharma, Dhamma, and the idea that sort of rights have to be earned by your personal behavior.
Yes.
And the sort of Western view that you have rights simply by being born, as it were. Do you think that's a sort of continuing tension?
There maybe it depends how one sees it. For instance, if I follow my dharma and don't harm other people, they can enjoy their rights. I'm not interfering with their life. That's how they can enjoy rights. So non-interference in the internal affairs of people, individuals' life, or life of a family or a society. So human rights, at the end of the day, the modern concept of human rights requires us to do the same thing by proclaiming these are our rights, and if the rights are violated, you have a legal recourse. That's the approach taken by the various international human rights instruments. But you can achieve the same by saying that don't harm other people. For instance, in Confucius, the Analects of Confucius, and in the Upanishads, it says that don't do to others what you don't want to be done to yourself. That's the very basis. Everybody can enjoy human rights if other people don't violate our rights. So through the root of duty and dharma or dhamma, the same is accomplished without necessarily having to go through the formal process of declaring rights and providing legal remedy for it. Of course, the approach taken by the United Nations Universal Declaration of Human Rights, and since then, has been basically a Western approach of pronouncing your rights, declaring your rights, and saying that, hey, you can go to courts to have your rights enforced. But looking at the issue from another perspective, that if everybody were to follow their dharma and not to harm other people, then everybody will be able to enjoy their rights. It's a reciprocity. The principle of reciprocity is in operation here.
Do you find yourself having arguments with proponents of Asian values?
Oh, a lot. Actually, there was a conference about 1.5 years ago in Barcelona. It's a very big conference. I was invited after my book was published, saying that, some new ideas here, and there were some grandees of human rights literature. They brought them together, and we had a very healthy discourse for nearly a whole day about different philosophies of human rights. I'm not saying that ancient Eastern scriptures had human rights in them. What I'm saying, they had human rights values embedded in them. Human rights is a legal concept, and human rights values as a spiritual, philosophical concept are two different things, but they complement each other.
And who won the argument?
I think we have to ask the audience, I think.
Right.
So far as some people were concerned, I won the argument. They came to compliment me after I made my presentation, but maybe some people went to compliment the other speakers. We never know. It's a big conference.
Do you think that the arrival of nation states has been part of the issue in Asia? I mean, empires, I guess, because they comprise lots of different peoples, in a way they have to be more tolerant, do you think? Whereas when you divide people up into nation states and you define a nation, do you think it ends up being a bit more intolerant because you're trying to say, this group of people are inside my nation and that group of people are outside my nation?
Indeed, unfortunately, that is the case, as you know, from Myanmar, Rohingya, where I think you have spent some time, and that's precisely the issue here. So that's the reason, whether nation states or some other concept, we have to accept the universality of human. That's the agenda. Whether you call it a Western agenda, I would say global agenda. And if everybody were to respect this global agenda represented by the Universal Declaration of Human Rights, and when people say human rights are neo-colonial Western agenda, most of the core international human rights treaties were adopted after the developing countries gained numerical majority within the United Nations. The 1965 Convention on the Elimination of All Forms of Racial Discrimination was adopted due to the initiatives taken by African states with the support of Asian countries. Even the mechanism, Universal Declaration of Human Rights, has no mechanism for enforcement or even compliance or monitoring of any kind. So the mechanisms were created in the 1960s, partly as a result of the apartheid regime in South Africa. There should be some teeth to human rights. So teeth was lacking in the Universal Declaration of Human Rights. So these treaties aim to do that one. They were adopted due to the initiatives taken by developing countries. So developing countries should take ownership as strongly as Western countries do about the current body of human rights law that is in existence today.
And do you think it requires a secular state to be a defender of human rights, or can you be an explicitly religious state?
I think, in my personal opinion, it has to be a secular state. That's the secularism is embedded in various international human rights instruments, and without having secularism, it will be difficult to for people to enjoy their religious freedom. Religious freedom is one of the main human rights that we have today. Whether under the Universal Declaration of Human Rights or the something called 1966 Covenant on Civil and Political Rights. So secularism is a requirement on the international law and should be so in countries around the globe.
So can you draw a distinction between a state that maybe claims the support of a religion or says, these values, grow from a Christian background or an Islamic background or a Hindu background or whatever, and yet still be secular? Do you think it's possible?
The heritage could be, Christian heritage, Hindu heritage, Muslim heritage, but the modern norms of human rights requires all states to respect religious freedom.
Mm-hmm.
When you respect religious freedom, then it will be difficult to maintain a non-secular state.
Mm.
So the problem with international law, as you know, today, international law is in some sort of disarray around the globe, from various incidents, events taking place around the globe. But one of the weaknesses of international law is that it has provisions for states to make reservations.
Mm-hmm.
After guaranteeing religious freedom in various international human rights treaties, some states can make a reservation saying that that particular article guaranteeing religious freedom will not necessarily be implemented overnight. In due course, they will have to be, because that's the whole global agenda. Mm-hmm. There can be no reservations on the provisions in the Universal Declaration of Human Rights. That's the reason I was pointing out in 2005, when the world leaders gathered in New York in the United Nations General Assembly, everybody accepted the legally binding character of the Universal Declaration of Human Rights. If you say so, then you are morally, legally bound to respect all human rights pronounced in the Universal Declaration of Human Rights, including religious freedom.
Do you fear that that might have been the high point for human rights around the world, and that we're seeing a kind of backsliding?
I would agree with you there. I think since then, the world has regressed a bit, and in the recent past, the regression has even become faster. So that is a bit disappointing. But again, human history has experienced these kinds of ups and downs. Ultimately, as I said, states will come around to accepting the norms represented in the Charter of the United Nations. Multilateralism, globalism, universalism will ultimately prevail, because the youth of the world today are very much, united in observing, adhering to certain global values. But you are right. 2005, if so far as an international speaking, by wearing my international lawyer's hat, I would say yes, you are right. 2005 was perhaps the high point for human rights. And
do you think there's been a problem for quite a few years? There was the talk of the responsibility to protect, that states had a duty to intervene in other states which were abusing human rights. But we don't hear so much about that now, and I wonder whether that was a result of things like the invasion of Iraq and that kind of thing. It sort of seemed to go so badly wrong.
Yeah.
Do you think there will be an obligation still for states to intervene in other countries to protect human rights?
Well, first of all, I have written an article actually after the so-called international intervention in Libya under the so-called right to protect, or sorry, responsibility to protect, R2P. What was it? How did it go wrong? So I have analyzed the legal status of the doctrine of R2P, responsibility to protect. To begin with, wearing my conservative hat as an international lawyer, there is no single legally binding international instrument which incorporates the R2P as a legal principle. It's more of a political principle in the making as an international legal principle, but not quite. When we say in international law, hard law principles and soft law principles, I will say R2P is an example of a soft law principle, number one. Number two, the events taking place around the globe sort of have impacted the development of international human rights law and international law generally, and international human rights law. So in the years to come, I think the responsibility to protect will come back. It was introduced by Kofi Annan when he was Secretary General of the United Nations. it is still on the international agenda, but it is now in the back burner. I think in due course it will come, and it has to come, in my opinion, to the front burner.
Mm-hmm. And you think that'll be driven as much by a generational change, that young people have grown up with these ideas of human rights and universal principles?
Indeed, I agree. I'm optimistic by very nature, and the youth around the globe. I have taught at 5-6 different universities around the globe, interacting with them, completely different expectations, ethos, and values. The youth of the present generation whole gives me some optimism that will be the direction the world will take in due course.
So you touched on the role of China and China's rise. It seems to me that China has a very much more state sovereignty point of view, that states should be absolutely the master of their own house, and that sort of reject the idea of any other states interfering. And obviously that seems quite an attractive framework for illiberal states, shall we say.
Yeah.
Do you see a danger to human rights discourse coming from that direction?
Yeah, I see a danger there, and I see a contradiction in terms there. Mm-hmm. Because those states which have become a member of the United Nations have accepted the United Nations framework, or if I can say so, the House of the United Nations is built on 3 pillars, principal pillars: collective security, human rights, and economic development. These are the 3 principal pillars of the United Nations. When we say human rights is one of the 3 principal pillars, then the whole United Nations agenda derives its authority from the Charter of the United Nations. So by accepting the validity of the United Nations, by joining the United Nations, every country has accepted the universality of human rights. That means other states have a right to express their concern when a gross and systemic violation of human rights takes place in any given country. Although there is a provision in Article 2, Paragraph 7 of the Charter of the United Nations outlining the principle of a non-intervention in internal affairs, but in my opinion, protection of human rights is not necessarily an internal affair. It's a global commitment, global pledge to work together to promote human rights. So the idea that by claiming to be a sovereign state, first of all, in my opinion, there is no state which enjoys absolute sovereignty today. Sovereignty is constrained by so many treaties, whether to do with the trade, commerce, human rights, social interactions. So this very much a qualified sovereignty states enjoy today. And one of those qualifications is human rights. So the argument that by claiming to be a sovereign state, this is our internal affair, it goes against the letter and spirit of the Charter of the United Nations. Those states which enjoy the membership of the United Nations, especially in the Security Council, should accept the United Nations human rights, validity of the United Nations human rights agenda. Basically, that when there are, of course, human rights violations are taking place daily as we speak in different parts of the world. Not everything catches international attention, but when there is a systemic, gross, egregious violation of human rights taking place in a given country, the international community has a right to express its concern.
And do you think the UN as a body, as a group of member states, can still drive a human rights agenda? I mean, we've seen in recent years the UN Human Rights Council membership has included a number of states which are seen as illiberal and unsupportive of human rights. Do you think that means that the UN has become incapable of pushing a global human rights agenda?
Well, not necessarily. First of all, I've written a book on the effectiveness of the United Nations human rights system, which came out in 2017. I've carried out a thorough assessment of each of the United Nations mechanism, in which I say the United Nations Human Rights Council is a talking shop. So who is elected in that talking shop or not doesn't make much difference, because it doesn't have much power to issue new declarations or impose sanctions on states which violate human rights. It's basically a talking shop which has its own usefulness, because states can come together, debate and discuss, criticize each other's record, and then send a message home that, hey, there is a room for improvement. That's well and good. But when we say the United Nations Human Rights Agenda, we mean basically the legally binding treaties and the treaties which have a provision for monitoring compliance. That is working reasonably well. Of course, that too could be improved, made more efficient, but the legally binding international human rights treaties are the one which I would say core of the United Nations Human Rights Agenda that is moving forward. Various agencies within the United Nations, so-called the treaty bodies established by these 9 or 10 core United Nations human rights treaties are working reasonably well and holding states to account. Of course, one would like to see more accountability, punishment for violators, so on and so forth, but the things are progressing in the right direction. So I will not be that pessimistic to say that the United, of course, it depends on who the Secretary General is, who the High Commissioner for Human Rights is, what sort of background they have, and are they the right people for the job, to lead the organization. That also makes a difference. But so far as the corpus of international human rights law is concerned, is a solid and sound.
And you think it can keep moving forward regardless of the fact that the Security Council is heavily split over geopolitics and current affairs?
Indeed, that's one of the drawbacks of the system. I have said in my book, the veto power is undemocratic. The United Nations is there to promote democratic values, but its own internal structure is undemocratic. These permanent five have a veto power, and some countries have used their veto power, abused their veto power every now and then to frustrate the whole system. But again, when looking at the totality, the total picture, there are weaknesses. As I said, in the Human Rights Council, every now and then has membership consisting of the violators of human rights. The use of veto power is frustrating. General Assembly doesn't have the powers to take binding decisions. When the Security Council is unable to take any decision, sometimes they have taken up the matter themselves, but again, it has no legally binding effect. But on the whole, educational value of human rights, more and more people are getting educated, are becoming aware of their rights, fighting for it. We saw in 2011-12 something called the Arab Spring, how encouraging it was. The people from in the Arab world, the youth, actually risked their lives to come out to the street, protest and assert human rights. That has had some positive impact on those countries. So generally speaking, because we have the right framework there, beginning with the Charter of the United Nations, adoption of the legally binding 10 or so core international human rights treaties, and a mechanism to monitor compliance and holding states to account. The mechanism may not be as effective as we would like them to be, but the mechanism is there and is working to a certain extent.
I just wonder if I could follow that. Maybe it's not directly on your topic today, but the use of the Genocide Convention and the various cases which are being brought at the moment on the question of genocide. Do you think that's the right way to go? Sort of, one state taking a case against another. I'm thinking about Israel, obviously, is the most topical one, but Myanmar as well, potentially. Do you think that kind of state-to-state case is a good thing, or does it risk the sort of the human rights approach?
Well, thank you. As you said, it's not quite an area I have covered in my presentation, and it requires another 10-15 minutes to go into that detail.
You got 3.
Oh, really? Okay. Very briefly, yeah, the Genocide Convention was created, adopted, within which it has a mechanism for states to, sue other states who, in their opinion, has violated the provisions of the convention. The International Court of Justice is now entertaining, as you said, these cases relating to the allegations of violations of Genocide Convention. And let's see, once you establish a mechanism, the mechanism takes its course, whether you like it or not, at a given period in time.
And for the rest of it, we'll have to read
exactly
book and another 15 minutes.
Exactly. It depends on what, because at the moment, in both of the cases you refer to, it's just a provisional measure. Provisional measures can be issued by the court if there is some prima facie evidence or indication to that effect. We have to wait and see what the court eventually says in its judgment, which is, I think, a couple of years away.
Right. So, just to conclude, would you say that you are an optimist when it comes to human rights? Do you see them becoming more universal? That all states will, have to embody them in their own domestic legislation and be held to account?
I am an optimist by very nature. And when we say human rights violations, we also should see the positive picture. Compliance with human rights. I have gone through reports after reports submitted to the United Nations Human Rights Council by the members of the United Nations as part of their periodical review. In every 4 years' time, every state is subjected to a review within the Human Rights Council. And then recommendations are issued. And many states have done their best to implement those recommendations. Of course, violations of human rights become headline news. Compliance does not necessarily become headline news. But very many states are complying and doing their best and trying to assert credibility. Hey, we are doing our best. We have resource constraints, this constraint, but we are doing our best. And we'll do the following in the years to come. That's the commitment they make. Whether they are truthful in their commitment or not is for us academics to examine, scrutinize, and then write about it. That's what we are doing.
Thank you very much indeed. That's been a really engaging and insightful presentation. So thank you, Professor Surya Subedi from the University of Leeds and many other institutions. This has been a webinar for the Royal Society for Asian Affairs in the UK. And we have a whole calendar of activities. And our next public open event will be a roundtable on the foreign relations of Mongolia. A state literally sandwiched between China and Russia, but desperately trying to seek its own agenda and its own place in the world. And that will be taking place on the 8th of May, and there'll be more information about that on the RSAA website. So my thanks to Professor Subedi today. Thanks to everybody for watching and taking part. And I hope to see you again soon at another RSAA event in the future. Bye-bye.